In this video, I want to talk about burdens of proof and how sure officers have to be to do certain things. Law enforcement decision-making kind of runs on a sliding scale of certainty, like a mental thermostat for how sure you have to be before acting. On one end, you got a gut feeling. At the other, you got proof beyond a reasonable doubt, the gold standard for a conviction. And in between sits the two important levels for police: reasonable suspicion and probable cause. Think burdens of proof as like climbing a ladder of certainty. At the bottom, you have a hunch, which is just a feeling. It's pretty much not enough for any legal action. Then you have reasonable suspicion. This is specific, articulable facts suggesting a person might be involved in criminal activity. Probable cause is the next rung, and this relates to a fair probability based on facts that a crime has been committed or is in the process of being committed. Then you have preponderance of evidence. This is generally used in civil cases, and this is based off a standard of like 51%. So more likely than not, a policy was violated. Then you have clear and convincing evidence, which is around like anywhere from 66 to 75% certainty. The standard is common in like civil cases or even Title IX investigations, again, requiring clear and convincing evidence that a policy was violated. And then you have criminal courts, which require proof beyond a reasonable doubt. This means that there should not be any uncertainty as to whether or not this person committed a crime. And so that's used in criminal trials. It's the highest burden of proof. Reasonable suspicion. This is the lowest legal standard that allows an officer to stop someone. And it was defined by the Supreme Court in Terry v. Ohio in 1968, which I explained in another video. While it's more than a hunch, reasonable suspicion basically relates to the idea that something seems off and officers are able to specify why they believe something is off. Probable cause means there's a fair probability that a crime occurred or that evidence of a crime will be found. So it's not proof beyond a reasonable doubt. It's just enough reliable facts to make a reasonable person believe criminal activity is happening. And the way I like to remember it is like, so stop and frisk, reasonable suspicion. Probable cause, probably because officers can articulate as to why they're going to search or make an arrest.